girlfriend of a Boston police officer whose body was found
in the murder trial of Karen Reed after the jury said it was unable to
they will retry Karen Reed
is
after a judge declared a
Welcome back to The Alternate. I am Tab, and I'm back from London, recovering from a little jet lag to cover day 31 of the Karen Reed retrial. Today was actually a really exciting day because we saw the defense wrap up its case, and in a shocking twist, the prosecution decided not to call any rebuttal witnesses. And so they both rested their case before they come back on Friday for closing arguments. What? That's right. We are almost done, you guys. Okay, so we kicked off our session at 9 o'clock this morning with Dr. Andrew Rentschler from ARCA, the defense's biomechanical expert, finishing up his direct testimony. He had begun that earlier on Tuesday, and Marga went over a little bit of his testimony yesterday. Defense attorney Jackson questioned Dr. Rentschler on a PowerPoint he brought in that reviewed Aperture's testing. Now remember, Aperture is the crash test dummy, blue paint guys. You know who they are, right? So in the beginning of the testimony, it was a bit long-winded.
Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those three separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next question.
I actually think he was winded because he wanted to say happy birthday to his son, Kai, on national television. So he tried to sneak this in.
You know, I have three kids. I have a 9-year-old who's actually...
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real-world example that you might want to use to explain some or part of the scientific method?
There is, yeah, and I would like to explain an example of what's important with that. So I was going to say I have three kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have two older ones.
All right, we're gonna stop this. Another example.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter, okay? Details in an investigation matter, and details matter here. You need details. You have to explain how things happen, okay? As an expert, I can't come in and just say...
Sustained. It needs to be more question and answer.
Clearly, Judge Cannoni was not having it, and he didn't bring up any more personal stuff from here on out. But honestly, great job, dad moment, if I have to say so myself. Happy birthday, Kai. And I saw online, like, all these people are saying happy birthday to this son who turned 10 today. So, I mean, hey, he got it in there. Dr. Rentschler continued on with breaking down John's injuries and how they could or could not happen. And clearly, Mr. Brennan was having none of it. He called so many objections that Bev called a very long sidebar to get things in order. And I'm talking within like the first, 10 minutes or so. And this sidebar was long enough for Bev, I call her, or Judge Cannoni, to actually apologize to the jury. He then continued to talk about John O'Keefe's sweatshirt, and a series of slides were put on the screen for the jury to see. And these, the sweatshirt had those small holes. There's 9 kind of small holes in the sweatshirt. Then he said this.
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Wow. Now, that for sure had to make the jury go, He makes a couple more comments regarding John's arm hitting the taillight. So let's hear one conclusion he made.
Did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or...
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Now, he goes on to review a little bit more on the testing with Aperture's surrogate, as he calls him.
Again, this is the paint test. This is the only test that was conducted by Aperture to look at the tail light and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
It's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24 Is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher. As it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear taillight of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
I mean, wow, this is all making a lot of sense to me and making me really question Aperture's theory. There is one more slide that I really thought you guys should hear.
This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point, as the car approaches, it would not contact the elbow or the bicep. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of pain on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that pain pattern.
After that, Rentschler then testified about a 29-mile-an-hour test conduct with a dummy using an SUV similar to Karen Reed's. This time, he said he conducted a center of mass test showing what would happen if John O'Keefe had been hit in the middle of his body instead of just a glancing blow. He said the test showed there was extensive damage to the rear of the Lexus, far more than we had in the O'Keefe case. It also showed that the trajectory of the dummy would be straight back in line with the vehicle and not somehow on the side of the lawn. He basically said it was physically impossible. Our testing demonstrates that peer-reviewed articles demonstrate that. This is exactly what he says. He says, our testing demonstrates that peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or side swipe blow, that somehow it would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that it could occur. So he's pretty set that John O'Keefe did not get hit by Karen's car. The defense then brought up an article that Aperture used in their report. This article indicated the head is the most common injury or most common body injury in a pedestrian impact involving motor vehicles. However, Dr. Rentschler said that, in fact, that was not accurate. This article, he says, was written in 1979, and the first modern SUV wasn't even manufactured until 1984. So this article is 46 years old, and it doesn't actually relate to the type of impact that occurred or didn't occur. That was the only also peer-reviewed reference with respect to a automobile pedestrian impact that was cited in the entire Aperture report. Ouch. That $400,000 is looking like money maybe not well spent. It was now Brennan's turn to try to catch all his runaway credibility, and it was clear he was not happy. He started by talking about John's body and where it was lying.
Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the question.
Dr. Rentschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Brennan then goes on asking Rentschler about being in bed with the defense. And of course, he didn't say in bed with the defense, but
Duration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio, force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Voir dire 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not, no, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all, no. It doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question, and I want you to give me a very specific
Objection, Your Honor.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare? You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see Let's try slide 56. You would agree with me, doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with a hand.
So
But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There was a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they used the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
Yep, I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again, did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking you.
Yeah, and I think it's
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your videos, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no. You don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have Exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged
part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower, or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Brennan continues to question Dr. Rentschler about John's pieces of clothing and taillight shards and stuff that had maybe gotten into the yard. And if the taillight shards were on the clothing, what would that mean? And of course, the answer was always the same. It wasn't part of the biomechanical process he was there for. So although he saw the evidence, it wasn't pertinent to his job. So he goes on, Brennan goes on to talk more about this taillight, and at one point asking if those shards found on John O'Keefe's sweatshirt, how they got there. I mean, he kept going on. And Rentschler just said it was not pertinent to what he was there to do.
Plastic under a microscope with fibers near the plastic. Is that something you would want to have considered in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
This really is how most of the testimony with Brennan went. You get the idea now that I played you a few clips. Jackson then came back up for a redirect with a few more questions, just trying to hone in on some key points. And then at the very end, Jackson tried to get Dr. Rentschler to say there was no collision. It was hard for him to say it because Brennan kept objecting and objecting and objecting. At the end of the day, he finally got it out that he does not believe that there was a collision. Brennan then got up and asked if John could have been just clipped by the car. Now, listen, I'm just going to give you a little piece here. I think in closing, he's going to play that clip of Karen saying, I don't know, I could have clipped him, something like that. I think that's why he's using that word clip. So he asked Dr. Rentschler if it's possible if there wasn't a, high impact collision, could John have just been clipped by the car? Well, Dr. Rentschler did hesitate for a second, but ultimately said no. And basically he said that because John has this head injury that ultimately was fatal because he couldn't move and he was out in the snow. He didn't say this, but that's kind of what he was insinuating, is that the way that John was found, and the way that the prosecution is trying to make it like she hit him, he fell backwards, he died, that just clipping him would not cause those injuries. So no, ultimately he said, absolutely not. Brennan then went on to ask about the drinking glass. And to that, Dr. Rentschler said he was aware that John had a drinking glass, but there's no evidence of it. There's no evidence that John O'Keefe was actually holding the drinking glass when he supposedly got hit by a car that Dr. Rentschler says he didn't get hit by a car. So he said there's just no evidence of this drinking glass in his hand at this particular, moment in time. Then we finished off with this.
You add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. If somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that tail light break, sir? How did it break that night?
I don't know. There's no evidence of how it broke.
Thank you. No further questions.
All right. You're all set, Dr. Rentschler.
Thank you, Your Honor.
And that was it, folks. No rebuttals, no more witnesses, just closing testimonies on Friday. Tomorrow is a day of jury instructions, so the jury has off, and we will not be here for that. Friday, we are expecting about 2.5 hours of closing testimony, so not that long. I think Judge Cannoni is giving them up to 1 hour and 15 minutes each, and then it's up to the jury to decide. So what's your opinion at this point? Let us know. If you listen on Spotify, you can write in the comments. If you watch on YouTube, you can also write in the comments, or you can DM us on any of our social media platforms. We have them all, and we love to hear from you. Please, please, please let us know. Margot and I will also be back together this week on Patreon to go over all of our thoughts on this before the verdict is read, which is really exciting. And that's probably if the verdict doesn't get read like right away, which I don't think is possible. But we are coming on to Patreon. So if you want to get on that, go to www.patreon.com/thealternate. That is a great way to just also support us for the show. And we really appreciate it. We have been growing really fast, and it's because of you. So please share us with a friend, give us a rating and review, and just keep connecting with us. Also, we are still working with the Diddy trial, and we will also be back with a Lori Vallow kind of a wrap up. It's going to almost be a one and done episode because I was going to do a weekly recap, but they just rested that case. I think they have closing arguments tomorrow, but that should be done really quickly. And I can only imagine the jury is going to come back with a guilty verdict. I can't imagine anything else, but I will go over that because that was one that I was not familiar with before. And then we're going to be on to the Brian Kohberger trial come August. So we have a lot in store for everybody. So do not go away. We are still going to be here even after this Karen Reed trial. And listen, Karen is facing time behind bars. And if the jury finds the prosecution credible and does not, they think there was no reasonable doubt, then they are going to find her guilty and she will most likely face prison time. Or they're going to find the defense more credible and she will be walking free from this nightmare. Now, it is our job to think like a juror and decide like one too. Until Friday, take care and stay vigilant and stay safe, my friends. See you then.